Good afternoon, all participants in the forum, both those here with us in the room and further afield. We now will continue with the next panel, which is indeed a continuation of the discussion we commenced this morning on convention rights affected by the COVID-19 pandemic and by states' responses to the pandemic, including a discussion of the positive and negative obligations of the states. I was meant to say and inform those participating that the publication of the COVID handbook, the book published by the organizers, is now available on both online platforms as well as on the website of the forum. We have with us, as before, judges of the European Court of Human Rights, both former judges and current judges. What I will do is I will present each one before they take the floor. To begin with, the first speaker is Judge Darian Pavli, who is the judge elected in respect of Albania. He has been a judge on the court since January 2019. Before he was sworn in as a judge of the court, he has had broad and long experience in the field of international human rights. He's a renowned expert in the field of freedom of expression and access to information. And he will discuss the right to private life and freedom of religion. Darian, you have the floor.
Thank you, Mr. President, and let me start with the special thank you for the organizers of this event. It is the second time that I'm able to participate in this forum. I find that it is an extremely important and rewarding opportunity to be able to meet in some form and interact with our colleagues from our national level, from the region. I find that is rewarding very much in both directions, and in the absence of physical meeting, it is particularly to be appreciated the effort to at least have this somewhat interactive format. I've been asked to address Articles 8 and 9 of the Convention. I'll start with Article 8, which is one of the most fertile areas of our case law. So even if I tried, I think it would be absolutely impossible to try and cover every particular aspect or potential implication of the pandemic on Article 8 rights, which, as we know, they cover a wide range from the traditional classical right to be left alone to all the way to family life and quality of life, for example, when it is subjected to external nuisances. So I find that I've had a look at the handbook that has been distributed, and I'd like to warmly congratulate the authors. I think it is extremely helpful in terms of our relevant case law, so I'm not going to try and do that and repeat that. It's already been done already very well, so I'm going to just try and raise a number of questions more than anything as to novel aspects that might arise as a result of the restrictions on rights due to the pandemic. The first one I'd like to start with is there a general duty of prevention or preparedness on the governments when they face something of this nature? Now, there is something unprecedented about this pandemic in one sense, the scale of it, the global scale of it, how it permeates every aspect of our lives, and certainly I believe not in the life of the Convention, perhaps not since the so-called Spanish flu of the earlier century. We haven't seen anything of this kind, and so the question has not really a reason. But that could be one of the potential questions to come before national and international courts. I would just mention here that there's been criminal investigations and civil actions in at least France, Italy, and Spain brought against public health officials, government officials, by relatives, for example, of medical personnel who died in the line of duty, as it were, or relatives of persons who died in nursing homes. Some of these aspects were mentioned earlier today by the commissioner. So a question arises, especially with respect to particularly vulnerable groups, whether there was a duty on governments to have a general level of preparedness that would safeguard human life and human health sufficiently. There's one aspect of this duty that is, while the general aspect, I don't think it's sufficiently addressed in our case law because we simply didn't have to deal with anything of this nature. There is one aspect of it which I think it is well established, which is the duty to provide essential information in a timely manner. It's the Guerra v. Italy line of cases. And that is quite clear that particular aspect of it, it is incumbent on the governments to enable people to make informed decisions about the risks that they take and how to deal with them, with those risks in a private life. And so the information should be as complete as possible and based on the best available scientific evidence. There's a whole range of questions related to public and private employment. I think a potentially novel question that will arise is there a right to earn a living under Article 8, for example? There have been many disruptions in our daily lives, but certainly for a lot of people, especially in those in less advantageous economic situations, it has simply been a major disruption of their right to be able to work and earn a living. While the convention, it is often said that it doesn't include socioeconomic rights as such, but professional activities, or at least some aspects of professional activities, have certainly been considered to come under the scope of Article 8. And if there is any aspect of such a right under Article 8, how is that to be balanced with prolonged restrictions for public health reasons? The questions related, quite complex questions related to the liability of employers, public or private employers, because employers are, for example, concerned about potential legal liability for allowing employees to return to work. And in some places, in some jurisdictions, they have sought legislative immunity to be able to allow their employees to go back to work. And on the other hand, employees, for example, teachers groups, have sometimes resisted calls to return to work. And what may be relevant in this respect, at least in part, is we have a line of case law in our jurisprudence which requires employers to provide reliable information about precautions in potentially hazardous conditions at work, and that the safety protocols be based on scientific medical advice. And I can mention here Vilnes versus Norway, which was a case that involved sustained health damage to deep divers who were at some point employed in the Arctic waters in Norway, and Brinkat versus Malta, which involved asbestos exposure at work. Another set of issues have to do with family life and operation of the court system. I think they were mentioned by colleagues earlier this morning. They are related to questions of access to justice, but also substantive rights under Article 8. Custody issues, questions of domestic violence when they do not rise to the level of Article 2 and 3, rights of children. And in this respect, I would make 2 points. One, that in many countries they have tried, even though the activities of the courts have been severely restricted, generally they've tried to have some exceptions allowing for emergency handling of certain typologies of cases. My own country was not an exception. It had provisions which said we'll continue to hear cases related to domestic violence, child custody, adoption process, alimony duties, and children's rights. Now, how that has actually worked in practice, that's something that colleagues at the national level will have a better sense. But I will just mention here one case that was communicated versus Italy. So it's a case pending before the court. And in May 2020, it's DC initials versus Italy. This was a father who sought joint custody of the daughter after the mother had taken her away from the marital home. He sought urgent proceedings, and instead of setting a hearing date within 90 days, as the law provided for, the Italian courts set a hearing 7 months later. And so one of the questions that was addressed to the parties was whether this special Italian decree that ensured urgent treatment for issues affecting fundamental rights should have been implied in this particular case. So time is tight. I was going to talk about privacy and data collection and the various tracing methods, but I think that was already mentioned by colleagues early in the day, and I'm happy to discuss any questions. Maybe one thing that would be interesting in this respect is a ruling. There's been ruling by French courts, including the Paris Administrative Court, on the use of drones by the Paris police for the enforcement of lockdown in March 2020, and then the court decided that that was consistent with the European Union law and French law because it was not used for identifying individuals. On the other hand, we have a separate example from the Supreme Court of Israel in our neighborhood, where the security agencies, the intelligence agencies, the Supreme Court found were not authorized by the existing law to collect and process technological information for those who tested COVID positive and the contract tracing. And then the Supreme Court called on the legislator to provide the necessary statutory basis and transparent voluntary mechanism. And I think my colleague Tim Ike will say more later in this panel about legality and proportionality. Just a few words on Article 9 aspects, if I may just have another minute or two. There is an interesting overlap between Articles 8 and 9, and those are funeral arrangements because they affect both family life, but they're often very tied to religious traditions. And one example in the UK, for example, was that they amended the emergency bill for COVID measures to stop cremation against the wishes of Jewish and Muslim families, for example, because that is so inconsistent with their traditions. And I could also mention that in Italy and other places, there have been complaints that family members were neither informed nor allowed to attend funerals or perform rites for COVID victims. Other than that, I think the main issue under Article 9 of the Convention have been restrictions on religious gatherings, congregations, ceremonies, and especially towards the beginning they came in the form of blanket bans, so complete bans. And there's been rulings in at least 3 countries by the Conseil d'État in France, by the Constitutional Court of Germany, and the High Court in the UK, which largely went against, well, with the exception of the UK, where a full hearing, the matter was adjourned in order for a full hearing to be heard. The French Conseil d'État and the German Constitutional Court, as I understand it, they ruled against, they ordered the government to lift a blanket ban on meetings and places of worship and to have more tailored and proportionate measures that would allow believers to be able to meet by respecting the sanitary rules and conditions. And there's another case that has been communicated by the court, Communauté Genevoise versus Switzerland, which is really an Article 11 matter. So here I don't want to encroach on the next presentation, so I'll just mention it. My final point, I think we can see that there is a time factor in the way the measures have been adopted. The initial measures, I think it is fair to say, were driven to some extent by processes whereby governments were taken by surprise. There was a degree of panic, a fairly significant lack of knowledge about how the virus operated. And I think with time we've seen a certain shift towards more proportionate and considered restrictions. I think I'll stop there for now. Thank you.
Thank you very much indeed, Darian. You touched upon, I think, an issue which will be increasingly important, a fascinating reflection on the public-private divide, which has been an ongoing development in the case law. For those that have followed Article 8 private life case law, in the professional context as well. And I think it is true, as mentioned by Judge Pavli, that will be an interesting issue moving forward when COVID-related cases come to the court. The next speaker is my good friend, Judge Anja Seibert-Fohr. She began her service at the court in January of this year. Before coming to the court, she was a renowned international scholar in the field of international human rights and international law, public international law, recently holding the chair of public law, international law and human rights at the University of Heidelberg, and was also member and vice chair of the UN Human Rights Committee. Anja will speak about freedom of expression and assembly. Anja, you have the floor.
Thank you very much, President. First of all, I would like to thank the organizers of this event for this very timely organization, and also for a high-risk organization, because I have never witnessed throughout this year a conference like this being organized, and I really congratulate you on having this courage to go through it. I regret that we won't have the opportunity to engage in an active dialogue with all colleagues from the region. I appreciated it very much last year when we had the opportunity to really engage with the colleagues from the region in Dubrovnik. And it's my hope that next year, or perhaps in 2 years again, we can follow up on that. And also, in order to, in a way, send the message that despite all restrictions, we are able to handle the pandemic, and I think this will be an important message also from this conference. Now let me turn to freedom of expression and freedom of assembly. I think that one of the major challenges concerning the freedom of expression in the course of the pandemic has been to ensure that the general public is adequately informed about all the health risks and also about the measures taken by the governments in response to the COVID-19 pandemic. After all, I think that the effectiveness of the measures in response to COVID-19 depend to a very large extent also on public support. We shouldn't forget that. Because in the end, it's every one of ourselves who adapt to the situation, and therefore information is of crucial importance. This has led some governments to adopt restrictions on the freedom of speech. Now you will ask yourself why restriction on speech. Speech is not hazardous as, for example, perhaps assemblies, but there were some governments who, for example, forbade any kind of speech which might cause social unrest in order to protect the integrity and also the public order. Now, obviously, one of the major challenges are people who deny the existence of the pandemic. Nevertheless, even if we disagree with these people, I think this kind of speech is not devoid of any protection, because we protect speech not for its content, but for the speech, in order to have a lively debate, in order as a solid ground for democracy. Now, this is even more so when it comes to criticism of specific COVID-19 measures. Whether we agree with them or not, I think we have seen a very lively dialogue throughout the last half year about the appropriateness of some of the measures, which enhanced also the reaction of the governments. So criticism should not be prohibited, because it should also be valued even if we do not always agree with the specific criticism. So generally speaking, any speech is protected under Article 10, unless it is hate speech or if it calls to violence. So the protection of speech does not depend on its accuracy. And this is one, and I turn to the first case that I would like to allude to, a case decided by the European Court of Human Rights. It was the Hertel versus Swiss case, where a scientist was prohibited from declaring that food that had been prepared in microwaves was dangerous to health. The European Court of Human Rights decided that that this was about the debate affecting public interest in health issues, and therefore it engaged in a very careful examination of the proportionality. So the court did not hastily say the content of this speech cannot be rectified or is wrong or something, but it said this contributes to a public debate and therefore it enjoys also protection under Article 10. So even if with good intentions, speech must not be prohibited and should not be censored. Public debate must not be foreclosed. Nevertheless, the Convention allows restrictions on the freedom of expression under Article 10, paragraph 2, as we have seen in Ponson versus France, for example, where the court had to deal with the restriction of a photograph in an advertisement of tobacco products. Here the court said that health is a legitimate aim, which may justify restrictions on freedom of speech. So of course, we are in this balancing act in Article 10, where we need to engage. I will not address here the issues of lawfulness and proportionality because my colleague Tim Ike will go into these issues in more detail. But I would just like to add that the court usually engages in a high level of protection when it goes into proportionality, as evidenced in the Mamere versus France case, where the applicant was sentenced because he had accused the government of playing down the risks associated with the Chernobyl nuclear fallout. In this case, the court said this is a serious restriction on the freedom of expression, and therefore it called for a high level of protection. Now, I don't have a lot of time, but I would like also to address the right to impart information, which is also a very important aspect under Article 10. In Tomso versus Sensa versus Norway, for example, the court said that the media plays a very important role to impart information. The media, in a way, is kind of a public watchdog in a democratic society, and thus it has an important role also to foster public debate. Now, therefore, the media should be able to impart information and also ideas on all matters of public interest, including on COVID-19 related issues. The court explained that the margin of appreciation that the court leaves to the national authorities is circumscribed by this kind of interest of the domestic society in enabling the press to exercise this role as a watchdog. So, generally speaking, journalists should be able to exercise this watchdog function also in times of crisis, and perhaps even more so, in order to enrich public debate and to foster it. Of course, this does not give journalists carte blanche. The court has recognized that journalists, on the other hand, also carry responsibilities, and they should act in good faith in order to provide accurate information. Because if you want to exercise a watchdog function, that also means that you need to impart accurate information and reliable information. Now, so how can states deal with this problem, generally speaking, about disinformation? And we have been talking a lot about fake news lately. I think that instead of prohibiting any kind of speech, I think transparency is a very important measure, and that weighs into the proportionality analysis. So it is very important to inform the public, to have press conferences with all the caveats of the COVID-19 crisis, but in order to provide the general public with a lot of information, with the database, with the information, so that the media is able to exercise its watchdog function, and also in order to enable every one of us to consider what is going on, how to adapt, how to evaluate these steps which have been taken. So let me just turn very shortly, if you allow, Mr. President, to the final issue, the freedom of assembly. Now here, this is more tricky, I would say, because with the assembly itself, there comes a certain risk because people are getting together. When you express yourself, it doesn't usually have any kind of impact in terms of COVID. But with regard to freedom of assembly, the thing is more difficult because we are talking about a collective right over here. And the collective aspect, which is so important for the freedom of expression, in a way, at that same point of time, also gives rise to risk. However, even if we recognize that there is a right to assembly, this does not allow any kind of unfettered restriction, despite any kind of, even if we recognize that assemblies are associated with these kinds of risks. Courts have played a central role, I think, over the past month in ensuring that the measures that have been taken in response to COVID do not excessively restrict the rights on freedom of assembly and of expression. So what is called here again is a balancing exercise and an evaluation of the different measures in order to see which kind of measures should be taken in order to protect public health. A general ban, according to the jurisprudence of our court, is usually the ultimate ratio. So any kind of other step should first be evaluated before there is a general ban. This was recognized in Lashman versus Russia. So only if there is a real danger of resulting in disorder, which cannot be preempted by other measures, then there may be a ban on assemblies. Let me come to a close. I think what this very short survey shows is that even with very good intentions, governments are not free to restrict freedom of expression, even if they want to avoid the proliferation of COVID-19. After all, what we can see is that the freedom of expression and the freedom of assembly may even be instrumental for an effective fight against COVID-19, because they are able also to enhance the dialogue and therefore also the effectiveness of all the steps that are taken in response to this pandemic. Thank you very much.
Thank you very much indeed, Anja. You touched upon, I think, probably one of the most crucial points from the point of view of simple democratic debate. The pandemic requires a robust debate simply because of the uncertainties in the policy which has to be taken from one time to another. So the free expression, the free information flow that needs to be enhanced and triggered in democracies, I think is a crucial aspect in this whole debate. And we may see cases arise where their limitations are put on access to information or the free flow of information because states will want to retain flexibility in the policy process. And I think that's going to be a big tension in all of this. Next speaker is not the speaker on your agenda. Vice President Ksenia Turković could not be with us today. We, however, have an equally brilliant substitute who will come and speak about freedom the right to education, property, and free elections. That is my former colleague, Judge Mirjana Lazarova Trajkovska, who was a judge of the European Court of Human Rights from 2008 until 2017, and served also as section president in the court, my section president, amongst others. She is now a justice of the Supreme Court of the Republic of North Macedonia. I thank you very much, Mirjana, for stepping in and giving us your thoughts. Please, you have the floor.
Thank you, Mr. President. Indeed, this was a short notice, but I must say I'm pleased that I'm here with you, my colleagues, and with my colleagues from 7 different places following our work. First of all, let me congratulate the organizers for excellent organization, but most of all to Mrs. Biljana Bretwhite and Mr. Goran Milic for their energy and the amount of work that they were raising in order to bring us all together. Thank you very much indeed. I will speak about the 3 different rights, and I will try to be brief because it is difficult to cover everything in 10 minutes. First of all, the right to education. We all know that as an emergency response to the COVID-19 pandemic situation, states physically closed schools, universities, and training institutions and took measures to try to deliver education remotely. States' innovative use of technology helped to protect the right to education of many students, at least to some extent, but provided less effective access to education for those without access to the digital infrastructure or technical skills. Under the Convention, the right to education is protected under Article 2 of Protocol 1, and in case of Memlika versus Greece, the court has accepted that protecting the health of children and teachers at school from the spread of contagious disease is a legitimate aim in pursuit of which the right to education might be limited. To ensure proportionality, authorities are required to act diligently and promptly to ensure that measures which are particularly restrictive, for example, preventing pupils from coming to school, are kept in place only for the time strictly required in order to achieve the desired aim. In the case of Leyla Sahin versus Turkey, the court stressed that the right to education is viewed by the court as indispensable for the human rights, and any restrictions on this right must not curtail the right to such an extent as to impair its very essence and deprive it of its effectiveness. Where education is moved online and via remote learning methods, if a student has no access to a computer or the internet connection required to engage in a remote learning system or lack the IT literacy to participate, then this will be in breach with the right to education to such an extent that the right is deprived of any effectiveness or essence. And we all know that this will be situation in many, many cases, and this will raise the issue of discrimination in connection between Article 14 and Article 2 of Protocol number 1. States have an obligation to make necessary and appropriate adjustments to the way education is delivered to avoid discrimination. Where education is mainly delivered through digital platforms, it is likely to have a discriminatory impact on the right of access to education of those from disadvantaged socioeconomic backgrounds and those living in rural or overpopulated areas. The closure of schools has also disadvantaged students with learning disabilities who may require counseling and additional support in their learning, and this was raised this morning by the High Commissioner on Human Rights. In Cham versus Turkey, The court pointed that states are under an obligation to be particularly attentive to the impact of their choices on how to deliver education, on the right to education of the most vulnerable groups. However, a difference in treatment will not to be regarded as discriminatory if it pursues a legitimate aim and if it is proportionate, and the court has accepted that a lack of public funds of resources might constitute legitimate reason to justify a failure of adjustment. This is a good basis probably for further discussion, but now I will move to another topic which is equally important. This morning, Mr. Rank mentioned that it will be difficult to prevent economic collapses, and I will say it will be difficult to prevent and protect workers. It will be difficult to protect owners as well and their property, and that's why we should be diligent how the right to property will be implemented. Lockdown measures taken to combat the spread of COVID-19 brought the closure of many businesses, of many public and private places of socialization and entertainment. Businesses which remained open were also forced to change how they are operating. And all these aspects and issues might be raised under the right on property protected under Article 1, Protocol number 1 of the Convention. Most measures taken to prevent the spread of COVID-19 or relieve its harmful economic impacts are likely to be regarded as a control of use or potentially a generic interference with the peaceful enjoyment of property. The court is generally reluctant to question a state's decision to interfere with Article 1, Protocol 1 rights, where they are responding to an emergency situation or as part of high-level decisions about the economy or the allocation of public resources, such as now in the case of COVID-19. In my view, there is a line of case law which might serve as a good basis for the further discussion at the level of the national courts and then at the level of the European Court of Human Rights, starting with the case of Mamatas and others versus Turkey. And here I will also mention the case of Asmudsson versus Iceland, where the court was clear that no measure should impose an individual an excessive burden on the affected persons or single out a particular group for adverse treatment. Issues might therefore arise if financial compensation or support scheme introduced in response to the economic effects of pandemic arbitrarily exclude certain businesses or individuals, or if they are deemed to impact a certain group more harshly than other groups. And then I will have to mention that it is important how long the measures will be implemented. Permanent measures are more likely to be deemed disproportionate than temporary measures. The longer measures are in place, the more important is to ensure that there are sufficient procedural safeguards for those subject to the measures to make representations regarding their individual circumstances and whether the restrictions are necessary and proportionate. I have one more aspect which was meant to be raised today, and I will briefly just go through most important elements of the right to vote. We all know that in the region, in past months, parliamentary elections were held during the pandemic crisis, and some elections are going to be organized. The restrictions imposed on free movement and assembly during the pandemic have impacted states' ability to hold elections and candidates' capacity to campaign in them, and elections have been postponed across the globe. Article 3 of Protocol number 1 of the Convention protects the right to vote and the right to stand for election. The COVID-19 pandemic may therefore interfere with Article 3, Protocol 1 in two respects. First, the postponement of elections risks enabling those in power to undemocratically extend their mandate to remain in power when they no longer represent the will of the people, in breach of the right to vote and the requirement to hold elections at reasonable intervals. And second, holding an election during the pandemic risks limiting the capacity of candidates to campaign, reducing voter turnout because of this and because of voters' fear for their safety. In the case of Molka versus Poland, the court pointed that if states decide to hold elections while freedom of movement and assembly are limited, and while public discussion and debate remains dominated by the COVID-19 pandemic, they must take specific measures to encourage free and public debate before an election so that votes are free and informed. So I'm linking this with Molka versus Poland because the circumstances in this case were similar to the situation where there was a limited circumstances for organizing elections. In system of elections, any system must respect the right to vote for all. The existence of organizing obstacles and additional costs are unlikely to justify any restrictions on voting rights in this context. Complaints concerning elections may be raised under other articles of the Convention, and such complaints apply to a wider range of elections, including regional and local elections. For example, the court has previously found an interference with Article 8 while polling stations were not accessible to individuals in wheelchairs and they were not permitted to take ballot papers outside. And this will be the case in the pandemic situation like COVID-19, even more often and more visible. Article 14 may also be raised in conjunction with Article 8 or Article 3, Protocol 1, where populations of a particular status are deprived of their right to vote. And here, Mr. President, I will stop. I am open for questions and discussions with our colleagues outside of this event.
Thank you very much indeed, Mirjana. You admirably were able to summarize the case law of the court on three very important rights, which I think are going to be, as a substantive matter, incredibly important and consequential for our review of, let's say it out loud, the collateral damage that may be caused by the COVID pandemic to certain rights. We move immediately to our next speaker, which is Judge Tim Ike, the judge elected in respect of the United Kingdom. Tim is a former barrister in the UK for many years. Started in '93 and took silk, as they say in the UK. Became a Queen's Counsel in 2011. He has recently been elected Vice President of Section in the court. He will speak about a transversal issue, the principles of legality and proportionality. Tim, you have the floor.
Thank you very much, Robert. As you said, my topic today is the principles of legality or lawfulness and proportionality, two of the Convention's core principles which effectively run through all the provisions, substantive provisions and rights we have talked about today, insofar as they either expressly or by implication allow for exceptions to or interferences with the rights they provide. And they are, or they provide the foundation for and are at the heart of the rule of law, what you, Robert, called this morning the lodestar of the Convention, and therefore are important. Now, let me start by looking at legality and lawfulness, and I will do that in a sense not so much by reference to our case law. We have little in relation to pandemic, specific to pandemic on this topic, and of course none of these cases have yet come to us. But it becoming clear clearer by the day when one looks at the domestic developments, that the unprecedented nature, at least in our lifetime, of the pandemic and the urgency with which measures had to be taken, at least initially, it is becoming increasingly apparent that the issue of legality and lawfulness plays an important role in the judicial control of measures taken in response to COVID-19. They are forming an essential aspect of any democracy governed by the rule of law, not only because they provide an essential protection against arbitrary measures taken by the authorities, but also because it respects the separation of powers between the judiciary, the legislature, and the executive, in that it protects the authority and the limits of the administrative action by reference to the limits set by the legislature. The requirements that have to be met in order for the measures to meet the test of legality and lawfulness are well set out in your manual, both under Article 8 and under the chapter Guarantees Against Abuse. But they are, in short, that 1, there has to be an identified and established legal basis for the measure taken, whether that is in the form of primary or delegated legislation, EU or international law, or another instrument made by someone exercising public law-making functions. But that's not where it stops. We then look at the quality of the law, and there the measure must be accessible, and we heard about that earlier, so that those who are likely to be affected can know what the relevant parameters for the behavior are, and it must be formulated with a sufficient clarity and certainty to enable those affected by it, if necessary with the assistance of legal advice, to regulate their conduct, to avoid breaking it, and or to ensure the consequences of breaking it are sufficiently foreseeable for them. And by sufficiently, the court means reasonably foreseeable for them. The fact that the law allows for a certain discretion does not per se render a measure uncertain, as long as the parameters of the exercise or for the exercise of that discretion are sufficiently clearly indicated. In that context, and Mirjana mentioned a minute ago, long-term measures and that they may fall foul of proportionality, I will just mention here the interim report by the Venice Commission on the measures taken in EU member states as a result of the COVID-19 crisis, where they recommend that, and I quote, declarations or measures that have no specific time limit, including those whose suspension is made conditional upon overcoming the exceptional situation, should not be considered lawful if there is no regular review of the situation. So they may actually fall at the hurdle before they get to proportionality by reference to lawfulness. Now let me just give you a number of examples, only one of which comes from our court. And they are in addition to, for example, the judgment of the Kosovo Constitutional Court of the 23rd of March of this year, which is summarized in your guide. The case I want to refer to from our court is a case called Foxley against the United Kingdom of 2000. And the reason I refer to it is because it is, for me, one of the clearest examples of the court looking at lawfulness, finding that a breach had no basis in law, and in fact, stopping the analysis there and not moving any further. In that case, the case concerned the activities of a receiver appointed under a confiscation order to realize the applicant's property, and in order to identify his property, the court made a time-limited order directing that all postal packages addressed to him should go to the receiver. Following the expiry of that date, some further 71 letters were redirected, opened, and photocopied by the receiver. As a result, the court found, in a very short part of the judgment, that the receiver must be taken to have known that the redirection order no longer provided her with a legal basis to interfere with the applicant's correspondence. As a result, the case was not in accordance with the law, and there's no need to look at proportionality. In the context of COVID, if you look at the domestic developments as recently as last week, the Madrid Court of Justice quashed an order of the Autonomous Authority of Madrid, who, in execution of a ministerial order of the National Health Department, imposed a so-called perimeter closure on Madrid, limiting entry and exit subject to exceptions. It's reported that that decision was not taken on the merits basis or on the proportionality assessment, but on the sole basis that the measure did not expressly refer to a material enabling law which authorized the regional health authorities to adopt restrictive measures of fundamental rights. In fact, it appears that the order only identified a generic legal provision detailing the cases in which the national and regional authorities act jointly in health issues. But this, the court found, was insufficient as a legal basis, which could have been found in another law, for imposing the measures restrictive of fundamental rights. So it's a clear example of a court looking at the legality and the legal basis not only being there, but also having been identified in the measure that is being taken. The second example, and it goes a bit to the point Darian made earlier in relation to data collection, is a judgment of the 28th of August of this year of the Constitutional Court of the Saarland, one of the Länder in Germany, where they quashed a provision on the collection and the use of contract tracing data by restaurants and other hospitality providers, as well as in relation to visits to cultural institutions, religious services, etc. Again, on the sole basis that there was no sufficient legal basis in the form of a statute. In that case, the government argued that, for example, it was justified by the General Infectious Diseases Act and or by the EU's General Data Protection Regulation, and the court dismissed that and said they were too generic and it needed a specific authorization. And interestingly, the court stressed that, and again I quote, that while regulations such as those to combat the corona pandemic are essentially drafted, discussed, and adopted within the executive branch, until they are published and citizens are thus confronted with a completed and binding regulation, a primary legislation adopted by Parliament guarantees the debate of the pros and cons in public, and thus an essential element of a representative democracy, a factor which of course assumes greater importance the longer an interference runs. And finally, for me, one of the starkest examples I wanted to draw your attention to is not as near as Israel as New Zealand, right the other side of the world, in a case called Barrowdale against the Director General of Health, who, despite the successes of the New Zealand regime in fighting the COVID pandemic, the High Court was confronted with a challenge to the Prime Minister's declaration that the country should go into lockdown on the 23rd of March. And the High Court, in fact, found that the period of lockdown was not in accordance with the law, despite the fact that the efficacy, the necessity, and the legitimate aim were accepted. And it was not in accordance with the law because without a prior order of the Director General for Health, a subordinate health official, the Prime Minister, in fact, had no authority to impose such a lockdown. The court reiterated again, and I think this is an important statement, that although the state of crisis during those first 9 days goes some way to explaining what happened, it is equally so that in times of emergency, the court's constitutional role in keeping a weather eye on the rule of law assumes particular importance, close quote. Now let's quickly turn to the issue of proportionality, which of course embodies the need to find a fair balance between the rights of the individual and the interest of society inherent in the whole convention. And it is the interest of society identified by reference to a legitimate aim recognized on the convention. And this, of course, does not only apply to the substantive provisions we've heard about, but also goes to the heart of the threshold for any derogation under Article 15, which we will hear about in a minute. But I should perhaps say, from the point of view of the court, that under Article 15, but also in the context of measures affecting national security or the implementation of social and economic policies, our court has always left a relatively wide margin of appreciation to the national authorities. And this was, for example, made clear in the context of Article 15 in the case of A and others against the United Kingdom. And that wide margin of appreciation which our court leaves to the national authorities applies both to assessing whether life of the nation is threatened by a public emergency, as well as deciding on the nature and scope of the derogating measures necessary to avert the emergency. But it is perhaps important to stress for those of us from the national courts that the court in A and others also made clear that one, ultimately it is for the Strasbourg court to rule on whether the measures were strictly required, the test being that the court must be satisfied that it was a genuine response to the emergency situation and that it was fully justified by the special circumstances and that adequate safeguards were provided. And secondly, and this I think is particularly important, the margin of appreciation we allow to national authorities cannot have the same application to the relevant relations between the organs of a state at domestic level. The consequence of which is that the question of proportionality is therefore ultimately a judicial decision by the national courts when a challenge comes to them. Again, you will find a couple of examples on proportionality, particularly from the region, in the guide. But as you can imagine, further examples arise on a now almost daily basis in the domestic courts. And if one follows them, they also demonstrate how difficult these assessments of proportionality can be, if only by looking at cases wandering through the instances where different instances disagree as to the consequences. The example closest to us, both in time and space, certainly to those from the court, is the decision of the Administrative Tribunal in Strasbourg in September this year, where they again suspended a decree by the prefect of Bas-Rhin requiring the wearing of masks in all public places in cities over 10,000 inhabitants. The tribunal quashed the order prospectively and ordered the prefect to produce a more tailored restriction on the basis that the blanket order was disproportionate, noting that certain areas and at certain times the population density was not such as to justify the interference with the applicant's rights. The Conseil d'État, on an appeal heard on a Sunday, impressively, and decided on a Sunday night at 11 o'clock, disagreed and overturned the order of the first instance tribunal. Nevertheless, they also directed the prefect to issue a new order in which he would define the areas more clearly, again, in a sense going to legality, in which requiring the wearing of masks was justified by reference to the density of the population or the difficulty of maintaining the necessary personal distance. And the final example, and with that I will close, is, I think the case mentioned by Darian is a decision of the French Conseil d'État on the 18th of May this year, where the court was asked and did quash an order that prevented religious communities from holding services during the initial period of deconfinement. So this was a measure coming out of the first lockdown, and they had enabled the opening of shops and schools and universities, etc., but not places of worship. And the Conseil d'État quashed that order on the basis that less restrictive measures were clearly available, see the other places where an opening was possible, and the absolute prohibition was therefore disproportionate. After all, less restrictive measures were identified by reference to those, as I said, applicable to transport services, as well as shops, commercial centers, educational establishments, and libraries. So one can see both these concepts at work, but it seems to me, at the moment at least, that actually, certainly with the first wave, as it is being called, whether it is or not, lots of the instruments, actually the analysis in accordance with the law and the lawfulness is where a lot of the problems will arise and where a lot of the solutions for the courts will be found, proportionality being, in a sense, the much more difficult exercise, and also the one where the difficulty of weighing trespassing into the realm of the legislature and the executive is greater for the courts. So thank you very much.
Thank you very much indeed, Tim. Yes, indeed, those 2 points that you mentioned, the 2 elements are, I think, absolutely crucial for any meaningful debate about the role of courts in the time of COVID. 2 elements that I think bear emphasizing in this context of a regional forum where judges are interacting with each other is, first, of course, the Strasbourg court, when it comes to legality, is very much in a receiving position, having to look at the way the national courts have assessed the national legislation. So reasoning by the national court, engaging with the questions of legality in a meaningful manner are extremely important. And the second point mentioned by Tim as well, that the margin of appreciation as applied in the case law of the Strasbourg court is, of course, applied within the context of the relationship between an international court and a national court. There, of course, can be constitutional doctrines at national level that may have a bearing on the deference a national court would grant other branches of power, but those do not necessarily harmonize with each other. And that is, as Tim said, lessons that can be learned from A and others. Finally, we have, not least, Judge Faris Vehabović, who has been a judge of the court since December 2012. Faris was a former justice of the Bosnian Constitutional Court. He is elected in respect of Bosnia and Herzegovina. He was also vice president of the Constitutional Court of Bosnia. He served as vice president of section of the Strasbourg Court from 2019 to 2020. He is going to speak about a very important topic, which deals with derogations from the convention in times of emergency. Faris, you have the floor.
Thank you, Mr. President. Historically, the first draft of the European Convention didn't include any provision concerning derogation to the European Convention of Human Rights. It was introduced following suggestion of the government of the United Kingdom. Since then, derogation from European Convention is allowed only in limited circumstances. If a derogation meets the conditions set out in Article 15 of the Convention, state obligation to secure certain human rights will be modified or suspended. States that signed up to the European Convention agreed not to violate and sometimes to take steps to protect, to take positive obligation, the human rights listed in the Convention, such as the right to life and the right to liberty. Because we have the rights, the state has corresponding convention obligation. The European Convention recognized that sometimes states experience situations of extreme crisis. In those times, it must not be possible for a state to achieve all of the Convention obligations. So the European Convention provides some flexibility in that respect and provides states with the possibility to deal with the crisis and to derogate from certain convention obligations through Article 15. The effect of derogation is to modify or suspend some of the state European Convention obligations, provided that any measures adopted in derogating from the Convention meet the requirement set out in Article 15. States can only derogate from the European Convention in time of war or other public emergency threatening the life of the nation. No state has derogated from the European Convention due to the war with another state, which is interesting detail. Most derogations have been in response to internal conflicts and terrorism. In these cases, the states asserting their power of derogation claim that there is a public emergency threatening the life of the nation, which justified the temporary suspension of their convention obligations. The courts tend to give states wide margin of appreciation when it comes to deciding whether there is a public emergency threatening the life of the nation. And the first case where derogation took place was situation from 1956 in case Greece versus United Kingdom concerning the territory of Cyprus, which was not at that time yet an independent state. The UK has previously derogated from the European Convention in the 1970 following a terrorist act related to the situation in Northern Ireland, and for the second time in 2001 in the light of terror threat after September 11. When a state claims to derogate from the European Convention, subject to review by the court, it can take measures which would otherwise breach the Convention. Any such measures are known as derogating measures. For example, derogating state could pass laws allowing to detain people indefinitely without charging them with a criminal offense, which would normally, absent derogation, violate its obligation under Article 5 of the European Convention. But there are three crucial limits under Article 15 of what state can do, even once they claim to have derogated from the European Convention. First, States can only take measures derogating from European Convention to the extent strictly required by the exigence of the situation. This means that even once they derogated, states may not take measures which go beyond what is strictly required to deal with the threat. This limits derogation measures to what is necessary. This also means that courts can review derogation measures to make sure that they are strictly necessary. If the court concludes that they are not, the derogation is invalid. So the state's attempt to suspend its convention obligation will be ineffective, and the court is likely to find that the state has breached its obligation. In assessing whether derogation measure is necessary, court may consider, for example, whether it's limited in scope in time, and whether there are any safeguards built, such as procedures for review. In the case of A versus United Kingdom, the European Court found that derogation measures taken by the UK post 11 September situation were disproportionate, not strictly required by the exigence of the situation, because they were discriminatory against foreign nationals. Second, states can never derogate from non-derogable rights. There are certain rights from which states can never derogate, namely the right to life, except for death resulting from lawful acts of war, freedom from torture and inhuman and degrading treatment and punishment, freedom from slavery, the right not to be convicted of a criminal offense for acts which were not criminalized at the time they were carried out, and the right not to be subjected to a heavier penalty than one which was applicable at the time a criminal offense was committed. States' obligation to protect these rights can never be suspended. They are guaranteed at all times, even in situation of emergency. They reflect the most basic commitments of civilized democratic society. And finally, third, derogating measures must be consistent with the state's other obligations under international law. This means, for example, that if a state derogates from a European Convention in an armed conflict, where international humanitarian law applies, the state couldn't do anything in derogating from the convention which would be unlawful under international humanitarian law. When states decide to derogate European Convention or certain rights from European Convention, it is sufficient to notify the Secretary General of the Council of Europe, stating the derogating measures taken and the reason justifying them. States also have to keep the Secretary General informed when the derogation measures no longer apply and their convention obligation resume in full. Prior to the outbreak of the COVID pandemic, 9 states had relied on their right of derogation under Article 15. Namely Albania, Armenia, France, Georgia, Greece, Ireland, Turkey, Ukraine, and UK. The pandemic resulted in 10 new derogations, bringing the total number of derogations in Convention history to 45. Between March and April 2020, 10 states notified the Council of Europe of their intention to derogate their obligation under the European Convention to respond to the pandemic, namely Albania, Armenia, Estonia, Georgia, Latvia, North Macedonia, Moldova, Romania, San Marino, and Serbia. This represented an unprecedented number of derogations and sparked debate regarding whether the COVID pandemic justifies derogation under Article 15. Does the COVID pandemic constitute a public emergency threatening the life of the nation? There is little doubt that in many countries the COVID-19 pandemic constitutes or has constituted an exceptional situation of crisis or emergency which affects the whole population and threatens the organized life of the community. It is less clear, however, if the normal measures or restrictions to rights which are permitted by the Convention are plainly inadequate in the context of tackling the pandemic, and whether derogation is justified. This has led to a situation in which certain states have deemed it necessary to derogate from the Convention to implement measures which are broadly similar to those implemented by states who have not derogated from the Convention, but which believe the measures to be justifiable under the exemption contained in the Convention. While state may be permitted to derogate from Article 8 to 11 of the Convention, states are also permitted to interfere with those rights to the extent necessary in democratic society for the purposes of protecting public health, safety, and order, provided the interference is prescribed by law. Further, Article 5 of the Convention permits the lawful detention of persons to prevent the spreading of infectious disease. So the question remains open with some states, why some states took these drastic measures when there is sufficient space in Convention to respond to all challenges posed by the Convention. Thank you.
Thank you very much indeed, Faris. We have now about 20 minutes or 25 minutes. We're running a bit behind schedule. I decided not to be as draconian as Tim this morning, just so to have a potential debate now. We have quite a number of questions, but that is fine. We will maybe defer some of the questions until tomorrow morning. We have another morning where we are able to discuss these issues. So I would ask Krešimir to bring a first set of 1 or 2 questions for the panelists.
Okay, so we have 4, I would say, rather general questions which could maybe be answered tomorrow. They concern right to a fair trial, a right of access to court, segregation in prison, again, deaths in prison, and an interesting question about access to property. So maybe that's not necessarily covered in today's topic, maybe if you wish.
We could take that also up under future challenges because I think they crystallize one of the challenged areas. So we could do that tomorrow,
Okay,
yes.
so for all those who put those questions, they will be answered tomorrow. Then I have also 8 specific more questions to the panel today. Would you like to have 4 now and then? Okay.
Let's do the first 4.
First 4. First one was related to derogations in time of crisis and criteria to be considered by states. I think this was answered, but then maybe if you wish to reflect further.
Okay.
And in particular, related question was, is it possible to have a de facto derogation or in countries where derogations actually happen de facto, or we would say maybe de facto emergencies. The term here reference was made to Article 15 and in fact to situations where de facto some sort of derogations happen. Then again, question was asked about the obligations and duties of states with respect to right to education, margin of appreciation of states in that context. Then 2 interesting questions. One is about restrictions placed on funerals from the perspective of Article 8, and then also of access to elderly relatives.
Okay, let's start with the first 2 questions, which relate to derogations. I think, in short, I think Judge Vehabović has given the framework in which under current case law, derogations would be dealt with under Article 15. Faris, do you want to the de facto derogations, I would assume, are situations where states would, for example, enact state of emergency laws, but without lodging an Article 15 derogation. And how would the court then deal with measures taken, we've seen that before in our case, deal with measures enacted on the basis of such emergency laws, thus internally proceeding on the basis that there is a need to deviate from their human rights norms. Faris, maybe I would start with you. How would you see that, for example, under the qualified provisions, under the question of necessity, to what extent the court would take account of that type of situation? And maybe we can also ask some other panelists to take a view on that. Faris, please.
Thank you. I think that I provided those three criteria that are relevant for derogation, for possibility to derogate, and what should be done when one state decides to make such a formal statement to the Secretary to the Secretary General. But yes, it is possible for the state to de facto behave as a state that which not submitted formal statement to derogate from certain rights, but behaves as the one. Of course, it's possible, and as I said earlier, it is possible depending on the right, which rights were at stake in this particular situation. But it is possible, as I said, that there are certain rights in the European Convention. Most of them we mentioned today, Article 8, Article 10, Article 11, Article 9, that could be in de facto derogated, applying measures already provided in these articles. So there are rights that are that cannot be derogated in any way, as a right to life, but for example, as I mentioned, Article 5, it's possible to legally detain someone in order to prevent spreading infectious disease. So it's the same situation with the other rights under the convention, which provides certain possibility to behave not strictly in accordance with paragraph 1 of those articles, because usually paragraph 2 provides possibility to, under certain circumstances, that states has wide margin of appreciation in applying this article in certain extreme circumstances.
Thank you very much. Tim is going to say a few words about this before I move to restrictions regarding funerals, which Anja and I would ask Darian as well to say a few words about that. Please.
Perhaps just to add to what Faris just said, the question of de facto derogation is kind of at the interface between the derogation under Article 15 and what is a necessary and proportionate interference with the right. And of course, I've mentioned margin of appreciation. Robert Spano mentioned possible constitutional deference provisions, but they're of course limited by the content of the right ultimately. And there, I think a de facto behavior may be capable of satisfying the courts that they are permissible. But once it goes beyond that, we're entering into the formal Article 15 process, where it's then looking at the process of derogation and the authorization, in effect, of an interference with the rights, which would otherwise be unlawful. So that's the next stage. And there, it then triggers all the necessary formalities that Article 15 brings with it, both in terms of the process and in terms of the test, which of course Faris has so importantly laid out. So it's kind of on a gliding scale. A state may be able to behave to some extent, interfere with rights as long as that can be justified by the exigencies of the situation. But once it can't be anymore, you're into the formal derogation process under Article 15. And I think that's probably an important threshold to bear in mind when one looks at behavior, that there comes a point where necessity, proportionality, legality can't save the state anymore, and it actually needs to go into the Article 15 process.
I would like after then, when we come to the right to education, to ask Mirjana to discuss a bit the margin of appreciation. But first, Anja, on restrictions in relation to funerals.
Yes, thank you very much, and also thank you for the question. I think I will leave it to my colleague Darian Pavli to respond to in terms of Article 8, but I would think that this question also relates to Article 9 and Article 11, very importantly. And I would think that there's no ready answer to it, because after all, this very much depends on the situation on the grounds. If you think about Italy, for example, or New York, where it was literally impossible to have proper funerals because this was due to the tremendous outbreak, it was not possible. But that also calls for a nuanced approach. So not for, as has been pointed out by the colleagues, we need to re-evaluate things in terms of time. And therefore, the government also needs to evaluate the availability of alternative measures. Instead of completely prohibiting funerals, there may be other kinds of restrictions in terms of distancing, the number of participants, and the question where the funeral takes place. So ultimately, also one aspect that has been raised by my colleague Tim Ike is important here, which is the coherence of the measures. Because if any other assembly would be allowed and not a funeral, then it would be arguably arbitrary to prohibit funerals. I think there are so many different factors which needs to be weighed into this proportionality analysis that you cannot give a ready answer to this question. Thank you.
Darian, please.
Thank you. I mean, just to supplement, I mean, I think the question is a bit general, but I would say it depends on the nature of the restrictions on funerals. If it's a restriction just on the number of people who can participate in a funeral, and it's in line with restrictions on other kinds of public gatherings, then you'll say, well, it's coherent, it's reasonable, it's not being discriminated, it's treated like other public gatherings in terms of how many people in total, what distance they need to keep. I think it gets a lot more complex when you have more severe restrictions of the kind when the deceased, for example, no rights are allowed. The family, someone is put to the ground, for example, or cremated, and without any rights, without access to the family because of fears of contagion. And that, of course, is from a religious perspective and emotional link perspective is a much more serious restriction with the funeral rights in all of our societies. And I would think that that would need to meet a higher burden of justification, which is not to say it's not justified. We would have to look at the scientific rationale for that, but the burden would be higher. If I may, I think there was a question on access to elderly relatives, which also falls largely under aid, family life. Again, the different contexts here. It could be access simply as a part of the emotional context of a family life, but I think our case law has made clear that there is higher protection when there is a relationship of dependency, when the elderly relative is actually not self-sufficient and depends to a larger or smaller degree on its relatives. And if that's the situation, again, one would have to look at the proportionality. I think part of the problem was at the beginning, a lot of the restrictions were very broadly cast. And then with time, reasonable exceptions were introduced. And there again, that would be the question. Is there a reasonable exception to the general rule that would allow some margin for those situations where the interference is very high. I mean, you had some fairly difficult situations in the beginning with the movement restrictions. You can imagine two parents sharing custody of a child. And if one parent couldn't move to be able to go to the house of the other and the child and so on, that would be a very significant disruption. Now, of course, with time, in many places, exceptions were introduced to allow for that kind of limited travel. But in the absence of such exceptions, of course, issues of proportionality arise.
Thank you very much. Before I give the floor to Mirjana about the right to education question, may I just chip in as regards these two issues that have now been mentioned, which is funeral arrangements on the one hand, access to old age homes to meet grandparents or parents and so forth. Here I think it's absolutely crucial that at the outset, to the extent that both types of situations involve an interference with rights under Articles 8 or 9, that there is a legislative framework on the way in which decisions are taken and the criteria for such decisions. I'm afraid we are seeing that when it comes, for example, to access to old age homes, decisions taken there are often taken, I think, in a legislative vacuum. And you have to make do you, for example, for convention purposes, make a distinction between a publicly run old age home on the one hand and a privately run old age home on the other, where you're dealing with horizontal rights potentially and the state's positive obligation? And I think here this is an area where the fundamental starting point, and also taking up the point mentioned by Judge Eicke, the issues of legality and legislative framework are going to be very important so as to formulate the subsequent proportionality analysis, because that really cannot take place without the criteria and the legislation already being in place to formulate the decision-making process. Mirjana, please, the right to education and the margin of appreciation.
Thank you, Mr. President. Well, I will say that even in 1968, in Belgian linguistic case, the court was pointing out that the right to education provides individuals with a right to effective access to educational institutions. What does it mean, effective access in pandemic situation is left to the states. How the system of education will be organized is precisely under the margin of appreciation. But this does not mean that the measures which are implemented from a side of the states which are particularly restrictive, like preventing pupils from coming to school, should be kept on a long term. So these measures, despite the fact that are under the margin of appreciation of the state, should be kept in place only for the time strictly required in order to achieve the aim of these measures. This means that the measures should be reasonable, necessary, and proportionate. Everything which goes beyond these criteria will be in breach with the Convention and with Article 2 of Protocol 1. And let me come to the first topic. I will use this opportunity when it comes to derogation. De facto or de lege, countries are obliged to keep their focus on the standards and principles prescribed by the Convention, and everything which goes beyond the Convention, everything which will be unreasonable, unnecessary, unproportionate as a measure for the moment when pandemia is going, or everything which will be misused in a direction of justifying measures which are not in line with the pandemic situation, sooner or later will come in front of the court. Thank you.
Tim, you wanted to add?
Yes. Two things really. One, I think in relation to the education question, to reiterate a point Mirjana made in her opening remarks, and that is, I think even if one looks at the margin of appreciation only under Article 2 of the first protocol, that's one question. But we're seeing in practice that a lot of this, there are lots of issues about direct and indirect discrimination. So I fear that actually some of the questions which might be asked under the margin of appreciation actually fall to be addressed, or could fall to be addressed, by reference to the concept of discrimination in relation to education. It's access to computers, IT, Wi-Fi, all of that, the different socioeconomic differences, and I think that's worth bearing in mind, that it's not necessarily only an analysis under Article 2 of the first protocol, but in particular in the concept of education, to some extent also property, there's a discrimination element to it which is important. Can I just make one other point in relation to the Article 8, which seems to me to be important, and that's, both Darian mentioned it about the stronger emotional bonds with elderly people, and you, Robert, of course, assumed an interference. I think one of the problems with our case law at the moment is about the existence of family life between adults. And therefore, one of the challenges, I think, for the courts, and for us eventually, will be to establish whether there was family life between an adult and their elderly parent. And it needs to establish, according to our case law, particular or especially special emotional bonds. And that, to some extent, is an emotional question. And that may be answered, one assumes, differently in the context of the pressures of the pandemic than it might be in other circumstances. Most of our case law relates to immigration, where that is a different issue. But I think the domestic courts need to be aware that that is an issue which I think evidentially parties before them will need to grapple with. Certainly insofar as the complaint is only brought under Article 8, because our case law there is in fact quite restrictive in relation to the existence of family life in relation to relationships between adults. The other question, of course, is whether it's a question of private life, either for the elderly or for the young old who want to see the elderly. But I think that might then bring in different tests. So I thought that was important to also outline and flag up.
That's a very good point. We will now come to a close for this part of our panel and discussion this afternoon. We have a number of questions which we will look at for tomorrow, and maybe pick and choose questions which will be conducive to a good debate under the panel on future challenges. I understand now that the hubs will take a mini break, and then they will continue until 5. Biljana, do you want to take the floor now and add anything, or? Okay. So I would thank the panelists on today's panel this afternoon, and of course for everyone that has taken the floor today, and those of you in the hubs, and we here hope to see you tomorrow morning. Thank you very much.